$225,000 fees on a $32,000 verdict. What reasonable attorney fees really mean for Oregon landlords. Hey everybody, Mr. Portland Landlord here. If you manage rental property in Oregon, especially Multnomah County, you probably saw that Oregonian story that dropped this morning. A Portland renter disputed a $287 electrical repair bill. 4 days after he sent written protests, the landlord raised the rent by $100. The jury found retaliation under ORS 90.385, awarded $16,000 in non-economic damages, and the court doubled it to $32,000. Now plaintiff's counsel is asking for roughly $225,000 in attorney fees. That's not a typo. $225,000 on a $32,000 judgment that itself started with a $287 bill and a modest rent increase. The landlord is appealing the liability finding, so the fee fight is still live. But the public record already gives us a perfect teaching case for every Oregon landlord and property manager right now, right in the middle of summer turnover season. I've been in this business long enough to know that most of us support legitimate fee shifting. When a landlord clearly violates the Residential Landlord and Tenant Act, the tenant should be able to hire a good lawyer without going broke. The reverse is true too. When a tenant files a weak claim and loses, the landlord should recover fees. That's the deal under ORS 90.255. The problem is what reasonable has started to mean in practice when the fee request is 7 times the damages award. Let's walk through exactly how we got here, what the statutes actually say, how courts decide these petitions, and what you can do both in the courtroom and at the Capitol to keep fee exposure from turning every repair dispute or rent increase into a high-stakes lottery. Quick recap of the trigger case. In late 2024 into early 2025, a South Portland tenant reported a smoking sparking outlet. The landlord's electrician replaced it and billed the tenants $287, saying the old wiring was the issue. The tenants refused to pay, wrote detailed protest letters, and pointed out they only had an alarm clock plugged in. The landlord kept sending past due notices. 4 days after the written protests, the rent went from $1,695 to $1,795. A neighbor in a similar unit did not receive an increase. The tenants moved out and sued for retaliation. After a 3-day trial, the jury sided with them. Damages were doubled under the statute. Now comes the fee petition. I'm not second-guessing the jury on liability. That's for the Court of Appeals. What I am questioning is whether a $225,000 fee request on these facts is what the legislature had in mind when it wrote ORS 90.255. When the attorney fee request is 7 times the damages award, every Oregon landlord should pay attention. Here's the full operative language of ORS 90.255, still current as of this writing. In any action on a rental agreement or arising under this chapter, reasonable attorney fees at trial and on appeal may be awarded to the prevailing party together with costs and necessary disbursements, notwithstanding any agreement to the contrary. As used in this section, prevailing party means the party in whose favor final judgment is rendered. It is reciprocal. Landlords win fees when they prevail. It applies to both trial and appeal. And Oregon courts have held that the prevailing party is ordinarily entitled to fees absent unusual circumstances. That part is settled law. The fight is almost always over the size of the award. How Oregon courts actually decide reasonable. The procedure is set out in ORCP 68. Within 14 days after entry of judgment, the prevailing party files a detailed statement of fees and costs that must explain how the factors in ORS 20.075 apply. The other side has a short window to object. Either party can request a hearing, and an evidentiary hearing is available. The substantive standard is the familiar lodestar method, reasonable hours times a reasonable hourly rate, then adjusted by the factors in ORS 20.075 subsections 1 and 2. The factors that matter most when the fee request dwarfs the damages are the time and labor required, novelty and difficulty of the questions, and skill needed. The fee customarily charged in the locality, the Oregon State Bar 2022. Economic survey is still the usual benchmark. Statewide median private practice rate for 2021 was $325 an hour, mean $344. Downtown Portland median was higher at about $380. The amount involved in the controversy and the results obtained, this is the strongest lever you have against a $225,000 request on a $32,000 judgment. Experience and reputation of counsel, whether the fee was fixed or contingent, and access to justice considerations. And the conduct of the parties, objective reasonableness of the claims and defenses, and diligence in pursuing settlement. Courts can and do cut hours, rates, and any multiplier when the request is disproportionate. Appellate review is abuse of discretion only, so the real battle is at the trial court level with a well-supported objection. And now a couple shameless plugs. If you own rentals in the Portland's Metro or Central Oregon and the thought of navigating a fee petition, or worse, an eviction that turns into a damages case, keeps you up at night, this is exactly why many owners hire Northwest Real Estate and Property Management. We handle the documentation, the notices, the court filings, and the day-to-day so you don't end up learning ORCP 68 the hard way. Check us out at www.nwrpm.com. And if you want the landlord forms, the monthly education, the legislative updates, and a helpline that actually answers when a tenant dispute is heating up, join PAROA at www.paroa.org. Membership is the cheapest insurance policy most of us will ever buy. Okay, back to it. Why $225,000 feels excessive and how to attack it. Here's a practical checklist you or your lawyer can use when a fee petition lands. Hours claimed versus the actual complexity. A discrete retaliation timeline built around a few letters and a rent increase notice is not a multi-year commercial case. Challenge block billing, administrative time, and overstaffing. Rate versus the OSB survey and local market for landlord-tenant work. Proportionality under ORS 20.075 subsection 2 paragraph D. Courts are supposed to look at the amount involved and the results obtained. A request that is 7 times the judgment is the definition of the factor that should drive a reduction. Settlement history. Diligence in settlement is an explicit factor. Preserve every offer and response. Fees on fees. Some requests include time spent preparing the fee petition itself. Object. Demand the evidentiary hearing. Bring a fee expert or detailed counter-declarations if the numbers justify it. Document everything from day one, repair billing rationale, consistency across units, timing of any rent increase relative to written complaints, and you make both the liability case and the later fee fight harder for the other side. That discipline is the same process advice I gave in the companion piece on the retaliation verdict itself. Know the 14-day clock. Missing the objection window under ORCP 68 can lock in an oversized fee award. What other states do? Most states with residential fee-shifting statutes also use a reasonable standard and similar factors. Hard dollar caps are rare outside small claims courts. Washington is one of the clearer examples of statutory breaks. Under RCW 59.18.290A, landlord generally cannot recover attorney fees in a possession case when the rent judgment is equal to or less than 2 months' rent, or $1,200, whichever is greater. Florida uses reciprocal reasonable fees with no hard cap. New York makes fees reciprocal if the lease has a landlord fee clause. California and most other states stay case by case. Bottom line, few states have solved the fees dwarf the damages problem with bright-line rules. Oregon could lead by adding explicit proportionality language or a rebuttable presumption that fees should not exceed a multiple of the damages absent special findings. Possible legislative reforms and call to action. Here are concrete ideas worth floating with your legislators while this Multnomah County file is still fresh. Amend ORS 90.25, 5 or 20.075 to require courts to give heightened weight to the amount involved factor. Create a streamlined track or modest fee cap for residential landlord-tenant claims under a certain dollar threshold. Strengthen early mediation or offer of judgment consequences in Chapter 90 cases. Clarify that contingent fee multipliers are unavailable or tightly limited when underlying damages are modest. Look up your state representative and senator right now. I've put the links in the description. Sample talking point. A $287 repair dispute that produces a $32,000 verdict and a $225,000 fee request chills ordinary property management. Please support legislation that keeps fee shifting proportional. Summer turnover is already producing more disputed charges, more rent increase notices, and more written complaints. Those are exactly the fact patterns that feed into the litigation pathway we just watched play out. High-volume helpline themes, late fees, security deposit accounting, move-out disputes, and repair documentation all sit on the same continuum. Getting the process right and pushing for clearer guardrails on fees protects the entire market. Practical takeaways checklist. Budget for fee exposure anytime a written tenant complaint is pending. Notify your insurance carrier early. Preserve every settlement communication. When a fee petition arrives, calendar the 14-day objection window immediately and demand a hearing. Keep repair billing documentation tight, rent increase timing clean, and treatment consistent across units. Contact your legislators this week while the example is still hot. Oregon's reciprocal fee shifting statute is a good idea when it levels the playing field. It becomes a problem when it turns every modest dispute into a six-figure risk that ultimately gets priced into higher rents and fewer available units. Courts already have the tools under ORS 20.075 to rein in disproportionate requests. They should use the amount involved and results obtained factor more aggressively. And the legislature should give them clearer direction so that ordinary property management does not require lottery ticket risk tolerance. So here's my question for you in the comments. What do you think is a fair multiple for attorney fees when the underlying damages are this modest? Drop your thoughts below. I read every one. Hey, if you're a Portland area landlord, come join the community over at www.paroa.org. We've got education, forums, networking, and we fight for your rights at the legislature. And for owners in the Portland's Metro or Central Oregon looking for hassle-free management, check out the pros at www.nwrpm.com. Join paroa.org today. Like, subscribe, and comment.